Thank you all for attending our second webinar. This will mainly be a question and answer session, so please send in your questions to lpfm@fcc.gov or using the hashtag LPFM questions. Before we start answering questions, I do want to spend a few minutes just reviewing some common questions that we've been getting. And so one reminder that I'd like to remind everyone about is that the window is now open. The window is currently open, and it has been extended to November 14th, 6 p.m. EDT. We would encourage everyone to file sooner rather than later, and you can start filling out applications now. You can also test file your questions and to see if you have any errors. So we would encourage you to do that right away. We also encourage you to print and download the Form 318 and the instructions. The instructions are very thorough and can be very helpful to you as you fill out your application. Also, a reminder that when you fill out the applicant's name, you should use the nonprofit organization's name. Do not list any individual as the applicant's name, because then your application can be dismissed. Again, the applicant's name must be the nonprofit organization's name. Also, last week we released a 6th order on reconsideration, which addresses a number of petitions for reconsideration that were filed in response to our 6th report and order. I would encourage all applicants to review the order, but some of the key issues and points that applicants should be aware of are: 1, the applicant must maintain the accuracy of the information provided in the application. So any changes that may negatively affect the applicant's claimed points must be disclosed in an amendment to the application. However, an applicant cannot seek to add points after the close of the window. Also, with respect to the protection of translator input signals, we are now requiring that any LPFM applicant proposing to operate near an FM translator station must demonstrate that no actual interference will occur at the translator receive antenna instead of at all locations, which was the original requirement. And finally, another point that we discussed in the reconsideration order was that an application for an LPFM station must protect both translators and translator input signals that were in use or proposed for use in an application prior to June 17th, which is the date of the public notice. Another common question that we've received is in relation to question 4 in the legal section and question 1 in the point system factor section. So to certify that you're local and that your headquarters is based in the community, you can either state that your organization is physically headquartered within the proposed transmitting antenna, or 75% of your board has to reside within the proposed transmitting antenna. You do not have to satisfy both of these conditions. It's one or the other. For those applicants who are relying on the provision of public safety service for your eligibility, we remind you that the primary purpose must be for the provision of public safety service and should not be ad hoc or sporadic. Thus, an applicant proposing to use the LPFM station to provide public safety service, we expect that service is the majority of, that the public safety service is the majority of programming. So the majority of programming should be public safety related. Also, when filling out the form for the FRN, which is the federal registration number, since there is no option for the nonprofit organization when selecting a business type, a nonprofit applicant should select private sector as the business type. Again, for the FRN, the business type should be private sector. That should be your selection. Additionally, nonprofit applicants should select exempted activities. I'll turn it over to Gary now to talk about some common technical and engineering questions that we've been getting.
I've got a couple things to add, and then we'll get going. Since the last webinar, there were a lot of questions that the RF exposure worksheets and environmental worksheets were not on the Form 318, and that's true. They've now been put on there, so if you go and get that form today, you'll get those worksheets, and you can complete those. Another thing we'd like to see is when people do second adjacent waivers, we got a few of them already since the rule changed, and we'd like to see some better exhibits, maps, aerial photographs, ground level views, something that shows the views of the zones where it's claimed that there's no interference. We've been getting some second waiver requests with just a statement saying there's no interference, and a simple statement like that most likely won't work. So just a little request for a little bit more additional information when you use the second adjacent waiver procedures to show there's no interference. And that's pretty much all I got. So we're ready to.
So at this point, we'll start taking questions. We already have a number of questions coming in, and I'll take the first one. The question is, do the Commission's alien ownership regulations apply to LPFM stations? The answer is yes. You must be an organization recognized under state law. And question 3 in section 2 asks each director's citizenship to be disclosed. So the short answer is yes. Do you want to go, Gary?
Okay, yeah, I'll take the next one. The question is, can you please discuss the Channel 6 interference requirements, Form 318, Section 4, Question 10. The requirements are contained in the Rule 73.827, and it's a spacing requirement rule that states based on the TV6 station how much distance you should have between your station, your proposed station, and the TV6 station. And you want to do the next one?
Sure. Next question. In a large organization like the Catholic Church in a diocese, when each parish and school in various communities is part of a corporate sole structure, will applications from parishes, schools in different towns be considered part of the same organization or by separate organizations? In this case, the state law governs. So if your state recognizes a corporate sole as a valid legal entity, then you can submit and are eligible for to file an application.
Okay. In evaluating second adjacent contour overlap, multiple parts of multiple questions. Let's try to do the best here. These are kind of difficult. 1A, can the applicant rely on vertical pattern from the manufacturer, or must it use the default EPA pattern in the FM model? And the answer is you can use the manufacturer's pattern if they have one, and use that to calculate your interference or contour distance. Can the applicant elect to use less than maximum permitted ERP to show compliance? Yes, you can do that. That's part of the what's allowed for the interference to make less interference to apply for that. And question 2, will MX applicants be given the opportunity to make technical changes to break MX conditions before staff eliminates them based on the point system? And the answer is yes.
Next question. Would a not-for-profit acute care hospital meet the jurisdiction requirement to apply for an LPFM construction permit if they commit to public safety and health programming? This hospital would like to coordinate programming with the county sheriff, EMS, fire, and emergency service agencies to provide service for the community. Yes, this would satisfy the public safety standard.
Oh, I have a couple.
Go ahead,
Barney. This applies to those organizations that have been around for a long time. Those organizations that have been nonprofit and recognized as such prior to 1950. If one is filing that a response to that question where it's asking for a date, the system at this point will only accept a date no earlier than January 1st of 1950. However, in Section 3, Question 1A about community presence, that's where you would indicate that the organization has actually been in existence and recognized as a nonprofit group prior, and then identify that respective date.
One question, if the nonprofit already has a location where they pay rent, do they also have to verify each of the addresses of the board members? So again, this is you can satisfy one of the standards. So if you're headquartered within the transmitting antenna, then that's sufficient. So you don't also have to verify the addresses of the board members. what type of documentation is sufficient to verify the date of your nonprofit entity's establishment? Does it have to be official, or can I use something like a phone bill or electric bill statement? In this case, we would strongly recommend that an official date be used, such as the date of a filing made with the Secretary of State's office. So if you have an official document, we do say you have to be recognized by the state's law. So if you have something from the state, I think that would be most preferable.
If my proposed LPFM station will be within 320 kilometers of the Mexican border, will I be able to file for an ERP of 100 watts? And yes and no. There's a delineation. If it's over 165 kilometers from the Mexican border, you can use 100 watts. If it's less than 165 kilometers to the Mexican border, then it's reduced to 50 watts.
Yes.
About the question about amending out of MX situations that applicants identify, it is important to note that any applicants that wish to amend to a non-adjacent channel, any of those types of resolutions must wait until the Commission releases a public notice announcing the mutually exclusive group. So applicants can file minor amendments at any time, but the major amendments to change your channel more than plus or minus 3 must be filed. They must wait until after we release the MXPN.
Next question. If we are filing as an emergency management entity, but our coverage area is predicted to go beyond our area of jurisdiction, can we still file as a public safety applicant? Yes, you can still file as long as you meet the requirements in 47. The regulation is 47 CFR 73.853B, which discusses local service. So again, the relevant CFR that you should make sure that you meet is 47 CFR 73.853B. So the question is, we are a nonprofit. It is the applicant. Is the nonprofit also a party to the application, or only the board members of the nonprofit? So both are parties to the application. Both the nonprofit is a party to the application, and the board members are also a party to the application.
Yeah, we just received a question about how long we expect the review process to take and when will applicants be notified. This is a difficult question just because we don't know the number of total applications we will receive in the window. Presumably, if we receive several thousand, we're looking to identify singleton applications within a couple of months of the close of the window, start announcing mutual exclusive groups. Some of the actions may start taking place by the end of the year, but most likely we're looking at the first few months of 2014 as far as issuing many of these decisions.
So next question is regarding a possible conflict between Form 318 instructions and regulations. The questioner asks or states that they are working with two community nonprofits that will both be applying for the same frequency. There's one individual who is a director of both boards, and according to our regulations, it appears to prohibit two applications under those circumstances. On the other hand, the instructions for Form 318, Question 5B, suggests that it is permissible if the party divests the interest prior to the operation and if the file number of the other application is included as an exhibit. However, our cross-ownership rule seems to apply an existing interest, not an application. So the question is, would it be permissible for two entities to file applications with one overlapping party if the party pledges to divest the interest, and an exhibit is filed as above. So in this case, I think you have noticed there is a conflict between the order and the rule, and so in this case, if you pledge to recuse yourselves from matters in the LPFM station, that will be sufficient.
I got one. If my church is going to put an antenna atop the roof and I have to file a second adjacent waiver, is it acceptable for my interference contour to overlap my church as long as it doesn't overlap any other buildings or major four-lane highways? And the answer is yes.
Next question, is a certificate of good standing sufficient proof of existence from the state in place of articles of incorporation? Yes, as long as that certificate of standing establishes your nonprofit status. So this next question states that the university has a full power FMC license. The station is an NPR affiliate with little student involvement. Would an application from our journalism college be limited or negatively impacted by the university's NPR station? So in this case, you could file if you meet the student-run station exception. And our form instructions do talk about this. So if the full power station is not run by students, you can file an LPFM application as long as the LPFM station will be run only by students. Another point to remember on that is you wouldn't qualify, right? Yeah, you wouldn't, and you can't qualify. You will not qualify for a new entrant point. So again, the student-run station exception is that the full power station has to be non-student run, and the LPFM station has to be student run. But you cannot qualify for a new entrant point. We have one question. Can high schools and private colleges submit affidavits from the principal and superintendent respectively that they are nonprofit, or do they need something official from the state? So again, it's preferable to get something official from the state that does state your nonprofit status. So the preferable documents should come from the state, but you should file what you do have. But again, it's preferable to have something from the state.
We also have a question here. Describe briefly the governing rule parts and additional limitations on LPFM stations near the Canadian and Mexican borders. Some of you may know that most of these limitations all of these limitations actually come from treaties that we have with Canada and Mexico. The majority of the LPFM related issues have been codified within the rules. Most of these are codified within 73-807, where it generally sets forth the distance separations required to protect Canadian and Mexican stations and applications and allotments. I'm not sure if all the parts of the treaties are codified in the rules, but there are certain limitations such as low powers within the Mexican border zone may only operate with a maximum of 50 watts as opposed to the normal 100-watt limitation. But the majority of the restrictions are set forth in 73.807.
If you are a university with 31 members of the Board of Trustees, do you need to submit a recusal or affidavit for every board member? Also, what address should the board members list in the application? It's not clear from this question why every board member should recuse themselves. Again, recusal is mainly in cases where a board member has an interest in another media outlet. So that's where a recusal would come into place, again, if the board member has a interest in another media outlet. And the board member should show their actual addresses, which is their primary residence. So that should be the address listed on the application. Do you recommend getting reasonable assurance for your main studio location? So again, this is reasonable assurance regarding the main studio location. The answer is no. Reasonable assurance is only needed for your antenna location. You don't necessarily need a lease, but there has to be a meeting of the minds that the antenna location is available for your proposed situation. Again, no reasonable assurance for your main studio, but you do need reasonable assurance for your antenna location.
All right. I have a question regarding FRNs. If my organization has an existing FRN for another radio service, can that be used for my low-power FM application in CDBS, or do I need a new one, rather? No, you're going to go with the organization's FRN so it's consistent, so it tracks with that entity. So stick with that FRN.
But just a reminder that we do have, there are exceptions, but there are in general prohibitions on owning multiple licenses. So just a reminder that in general, you're only entitled, you can only have one LPFM station unless you're a tribal entity, and you cannot own an LPFM station and another media outlet. There are some exceptions that are listed in the Form 318 instructions, but in general, you are prohibited from owning another media outlet and an LPFM station.
And the question itself actually should have been a telltale sign to me or the applicant that you've already have one on board. Stop there.
Okay. Can you clarify for sure what devices and systems must be protected from and which the licensee does not need to protect from blanketing interference from its radiated RF signal? It's the rule that for all the FMs, other FM stations, the FM standards is in Rule 73.318. That's the same thing applies for the low power FM stations.
So next question. Although we have reasonable assurance, a reasonable assurance letter for our transmitter location, and we are planning on locating our studio at the same location if possible, we do not have a phone number yet, and we are not sure that we can come to terms on rent. Can we still list the location as our studio address for a point on the application without a phone number? So it is important to have contact information, and so I think in this case, I would suggest using your cell phone number if there's no other option. It doesn't have to be a landline, but in general, providing contact information is very important. So if you don't have a phone number, you could list your cell phone number.
So I actually got a follow-up question to the Canadian and Mexican question. And I will say, it's quite a specific, application-specific question. I will provide a bit of a general response, and the person is asking if they would comply with the spacing requirements at their specific site. And generally, the maximum distance, as long as you're 124 kilometers from any Canadian or Mexican station, in any situation, you should be fine. I would say just about the very applicant-specific questions, we expect to be responding to most of these emails directly, so we can give you more personal attention to some of your questions if you might have very case-specific questions like that.
When the FCC grants the application and the applicant a construction permit, does it at the same time assign their call sign, or is there a separate application for that? Actually, it's a separate activity and application, if you will. The complete process is three main steps to get your station on the air, get licensed. And the first is doing this Form 318, the construction permit, when you get your construction permit granted, you come to the FCC's call sign reservation system, and that's when you go through that system and get your call sign. And then once you've built the station and you have your call sign, you are ready to go on air and you begin testing. Is when you file the Form 319 license to cover. So the three main steps are the construction permit, getting the call sign, and then getting the license. So the call sign is kind of a separate thing, step 2, if you will. So get the construction permit granted and then go for your call sign.
Next question. If a board member has a past felony, what information must be disclosed and in what form? So there has to be a disclosure. And you should file the information in an exhibit pursuant to Section 2, Question 7. Just a note or a reminder that it's not an automatic disqualifier, but you do have to disclose it in an exhibit pursuant to Section 2, Question 7.
We just received a question about how many applications have been filed in the window. What I can say is that applicants have been filing since the government reopened on October 17th. We cannot provide details at this time as far as the number of applications. It's an important part of the process that we keep this information private while applicants are filing in the window, so as not to disadvantage anybody who may be applying for a certain spectrum in certain areas. So we will not be revealing any detailed information about the filings until at least the day after the close of the filing window.
Okay, next question, two-part question. Why doesn't the application ask for the ERP, effective radiated power, the ERP? It doesn't because we calculate it for the applicants. It's just something that the LPFM service does. So you give us the important pieces of information that are needed are the site elevation, the ground level, above mean sea level, and the antenna height, and the coordinates. And then we will calculate the effective radiated power. And the second part of the question, if I'm not filing a second adjacent waiver, but the antenna height above average terrain is greater than 30 meters, doesn't the FCC need to know the ERP, the effective radiated power we are proposing, since it must now be less than 100 watts? And it's the same answer. If the antenna height is greater than 30 meters above average terrain, we will calculate the ERP based on that, and of course it will be a lower than 100 watts full power. So we still calculate that, and it's based on your the parameters you give in the tech box for the site elevation and the antenna height is what we use. So we do the calculations, I guess, is pretty much the bottom line answer for both parts of the question.
Right, and it's very important to note, too, I mean, this is very important to folks that are proposing second adjacent waivers. You can propose a reduced power in your exhibit. So if you're giving us a second adjacent waiver, in that exhibit where you're documenting your compliance with the non-interference requirement, you can specify whatever reduced power below the normal calculated power you would like to be considered at. So applicants do have that control over the power that would be considered in the calculation.
Is there any consideration for first service of unserved populations such as immigrant communities? The answer to that is no. There is no consideration. Next question. The application appears to contain or require the names of 8 board members. Are 8 needed, or is a smaller number sufficient? More than 1 or less than 8 is fine if that's what your board is made up of, but you have to make sure state law requirements are satisfied with regard to your incorporation. What documentation is necessary to earn the established community presence point when an applicant's articles of incorporation or similar written instruments listed in the application do not establish community presence? Is an affidavit sufficient, or should the organization include other documents like leases and news clips about its local activities. So we need an exhibit pursuant to Section 3, Question 1. At this point, we don't require backup documentation. However, all applicants should remember that their applications will later on be publicly available and subject to review by competing applicants. So you should make every effort to be completely accurate in all aspects of the application and provide whatever evidence or proof that you have regarding your established community presence.
I'll take one. The two questions. A university client in a rural area operates a low-power Part 15 campus radio system, which also feeds audio programming from the station to the internet and to the local cable CATV system, which donates a channel to the university. Audio programming occupies about 10% of the time on the channel. The rest of the time is a university bulletin board and background music. Two questions. This is on question 1. I understand the carrier current stations are exempt from attribution, FCC 0349, Note 119. Would this exemption apply to other campus-type stations, such as the referenced low-power Part 15 station, which would not be considered a broadcast station under Part 73 of the rules? If answer to B is affirmative, does the tie-in to the internet and or cable system change the answer? And no, it doesn't. So neither is attributable to a broadcast station, because they're different things. Part 15 stations and cable systems are not part of being attributable to a broadcast station. Question 2 is understood that a university applicant which is part of a statewide university system will not be attributed with full power stations licensed to other schools in the systems. And a cite to FCC 12-144. From this, it is presumed that the applicant need not survey members of the statewide board for their media interests or otherwise, since they would not be considered parties. Please confirm. That's also true. They do not have to look at the other stations for their broadcast interests, just the single university client, not the whole system.
Next question, how many LPFM stations can one nonprofit own? So you can only have one LPFM station, and I will also take this time to remind applicants you can only file one application too. So you can only have one station, and you can only file one application.
Go ahead, yeah.
All right, I've got a couple of similar questions on the mutually exclusive process. One person wants to know if the mutually exclusive list will come out before the staff applies the points system determinations, and also will we be announcing ties among applicants. It's really important to note that we're going to have multiple public notices announcing mutually exclusive groups, so we'll probably do it in batches just to keep the work manageable, particularly for the applicants that have the opportunity or obligation to file things after we release these public notices. So the public notices we release will basically be announcing the mutually exclusive groups, and it will be providing this opportunity for folks to resolve their conflicts, to file the major channel changes that I referenced earlier. And then it would be after that time where folks were given an opportunity to resolve their conflicts that the Commission would then be taking or making determinations on those remaining groups as far as the point winners and any tiebreakers that need to be applied after that point.
Am I correct that we can move the site up to 5.6 kilometers if a site change is required? That's a minor change distance. Jim, can you do a major change within the window if you amend during the window? I'm not.
Well, assuming the question is talking about after they're authorized.
Yeah.
Well, either way, if it's either while they're still pending or after they're authorized, they can certainly move that distance. The the eligibility rules still apply, so they're still going to have to make sure they're within the relevant distance to their headquarters and or within the relevant distance of the entities that represent that organization. But generally, yes,
Right.
people are able to make site changes within that limitation.
Oh, I got you.
Does a new private nonprofit organization have the same chance as well as a well-established entity in obtaining the LPFM license? We do give a credit, an extra point, pursuant to Section 3, Question 1, if the organization has been in existence for at least 2 years. So an organization that's been in existence for more than 2 years does have the ability to claim an extra point and does have an advantage there.
Oh, yeah. I needed a direct call, I would think. Do you want me to go ahead? If a second adjacent channel commercial station's main broadcast frequency overlaps our proposed frequency, but the same station has a repeater on a different frequency, specifically covering our community, do we need to worry about interference with the main frequency? Will the antenna manufacturer's contour help with the antenna that will be located in a residential neighborhood? And wouldn't the antenna location rules prohibit antennas being near any house, building, or will a specific antenna fix this issue? I guess there's three things going on here. The way we separate stations with low power stations is by separation, distance separations. So we don't necessarily look at contour overlaps. So I couldn't really answer if this would be on the first part of the question whether it would be a problem. The interference is if the spacing is correct, which you can't get authorized not unless you get the proper spacing. You shouldn't have this interference problem. So it's hard to say from what's being described with overlap. And the antenna manufacturer's contour is generically the low power FM service is a non-directional service. So the antenna manufacturer's contour should be the same in all directions. So I'm not quite sure why that would help or hinder a residential location. So I think a lot of those things are more not the antenna, but the geography of the surrounding buildings and topography and things. And antenna location rules on the third part, prohibiting antennas being near houses, buildings, or will a specific antenna fix this issue? That gets into RF exposure type of evaluations, and those would be done as we have in our radio frequency check sheets, worksheets that are on the application. They're pretty much distances, so the distance that the antenna is located from a house, a building, or where somebody could get close to the antenna is what we look at. So there's not any prohibitions other than that. So if use the worksheets, that should solve that problem.
I just want to follow up on a question that Gary answered just a little while ago about a university applicant which is part of a statewide system and whether or not stations licensed to other schools in the system are attributable. We have encountered this question before, and I just want to remind folks that if you are a larger university and your local campus wants to apply for an LPFM station, it has to be separately incorporated. So the local chapter has to be separately incorporated from the larger university. But the local chapter of the university has to be separately incorporated.
Oh, right. Yes.
So the local chapter, just in case I wasn't clear, the local chapter of the larger university has to be separately incorporated. So that's the way to avoid attribution is if the local campus, the local chapter, is separately incorporated from the larger university. Another option to consider, though, is if the station will be student run. So again, we talked about this earlier. You can have a full power or another license, full power station license, if it's not run by students, as long as the LPFM station will be run by students.
I've got one over here. Question 6, rather Section 6, Question 8B. This is dealing with interference through translators or booster input signals. And the question specifically is, or what the caller is indicating, he's saying it will not validate without an exhibit, even with a yes answer. If one is required, what do you do from there? If the answer to that question is yes, then you would provide within the exhibit the basis upon which you make that assertion. If there's been a study to reflect that there's compliance, that type of thing. I gather it would be basically engineering information that would be provided. I have a couple other quick follows. On Section 4, if you're applying for a public safety license, the city is established in, get this, 1888. But the form will not accept that date, as has been answered before. If you have a situation where the licensee or the permittee, the organization, I should say, has been in existence prior to 1950, when responding to that question and providing a date, it's going to be basically 01/01/1950. But then again, within the appropriate section, at Section 3, Question 1A, dealing with the community presence, you would go into greater details as to when that organization originated. And then finally, Section 2C, if you're applying for a public safety license, and it's the only application, I take it we're talking about a governmental entity here, but it won't validate if I check not applicable, okay to check yes. It's definitely okay to check yes. That's the only way in which that answer will be accepted, because that's the only application that you're filing for.
We have a question. If a nonprofit entity is awarded an LPFM license, can it lease the license to another local nonprofit to act as an operator entity? The answer to that is no. We do have a regulation that prohibits that. That regulation is 47 CFR Section 73.860E, which prohibits time brokerage or local management agreements for LPFM stations. So the short answer is no.
What qualifications are required of an engineer to submit an exhibit for second channel adjacent interference issues? Are there any examples of an exhibit regarding these issues? There's no qualification for an engineer. It just has to be a correctly done exhibit that demonstrates what needs to be done. And the main way that second adjacent waivers are handled nowadays, for the most part, are similar to what the translator waivers do, and that's in the rules, Rule 74, CFR 4774.1204D. There's showings that we use that are similar to translator interference showings that use the U to D ratio type of methodology. Although the rule does say that you can demonstrate use any kind of propagation or a demonstration to show no interference. So there's not one way to do it, but the typical way is using the translator unit undesirable to desired ratio engineering method.
Can separate applicants use the same main studio location? Yes. If we have already been operating as a web-based radio station with full-time programming, community presence, and national recognition for many years, should we include proof of that as an exhibit to show that we will meet and exceed the minimum programming requirements? Our application only states that you pledge to do that, so no evidence is necessary for us to credit that pledge. It's just a pledge, so no evidence is required or documentation.
let me go while you're reading. If we are a campus and the second adjacent interference zone is entirely within one campus-owned dormitory and none of the zone is off campus, is that acceptable for a waiver? And the answer is no, not unless you can demonstrate that there's no population in that dormitory. But I'm assuming that's a dormitory that's filled full of students, so there would be a population receiving the interference, so that waiver would not work.
We have a letter from the city stating their willingness to work with us on the city's water tower site. We were told we just have to have such an agreement or letter, but it's not necessary to attach it to the application. Would it be a good idea to attach it anyway for good measure? Attaching the agreement letter is not required. We just ask that you have reasonable assurance, but you do not have to attach it to the application. Please clarify, this is the next question, please clarify required minimum daily LPFM broadcast hours and content. I have read there's a minimum of 36 hours of on-air operation per week or 6 days per week with a minimum of 5 hours per day. These two requirements seem to conflict. This also appears to conflict with the requirement of presenting 8 hours per day of originally produced content. Please clarify. So we do have a minimum operating schedule, but the 8 hours per day of originally produced content is not a requirement. It is only to gain an extra bonus point for your application. So the 8 hours per day of originally produced content is not a requirement, but if you do pledge to produce 8 hours per day, you will get a bonus point in your application.
I have a question on this side regarding, if that's all right.
Mm-hmm.
If an applicant's purpose is a news station, which it will be, should it leave the applicant blank the box asking for a call sign? That's yes.
What if the proposed height structure fails TOWARE? TOWARE is a calculating program that is used to find out if your antenna structure requires FAA clearance due to aircraft obstructions. And the answer is, will applications that fail TOWARE and who have currently filed with the FAA be dismissed? And the answer is no. We'll just wait till you get that cleared up, and kind of puts the application on hold. But it's not a. You don't get dismissed for doing that because that's just something that has to be checked out. So the answer is no. It will not be dismissed.
As a municipality, is a public safety license the only kind of license we can apply for? No. A municipality can apply for an LPFM station that would not be used as a public safety station. In fact, many states and communities, particularly school systems, operate non-commercial stations.
With an antenna on top of City Hall, can the second adjacent interference zone encompass occupied areas of the building? And the answer is no. It has to be no populations demonstrated. So if the building has people in there, then you couldn't use the second adjacent waiver process.
Next question. What is the minimum number of board members required? That is a question of state law. So as long as you're in compliance with state law, that's sufficient for our purposes. Wimberley Valley Radio is a new applicant. The terrain in our valley and where the area's population live make it likely that the signal will not reach the entire population. For public safety and emergency communication reasons, there's interest and possibility of acquiring 1 or 2 translator stations eventually in the general area. The question is, do the rules for applying require us to first be on the air, or when is that allowable? So, 1, you can only apply for a translator when we have a window open for a translator, and to apply for a translator, even if it's going to be used for an LPFM station, holding the LPFM license is not required. regarding the parties to the application, please elaborate on the officer board member, percentage of votes, and percentage of total assets. So here is an example. If there are 4 board members, each board member would be listed as having 25% of the votes and 25% of the assets. In the non-commercial context, there is no ownership per se of an entity, so board members are treated as if they are all equal owners.
Oh.
The LPFM request is for a church located in Brooklyn, and the not-for-profit entity was established by the pastor. However, it was in effect for a little under 2 years, so 1 year and 10 months, and the pastor is newly elected to the church. But the church has been in the community for more than 80 years. What supporting type of explanation or documentation can we supply that will overrule the corporation being in effect less than 2 years? However, the church has been in the community for more than 80 years. So if the applicant is applying, if you're the applicant and you're the church and you're applying as an incorporated entity, then the incorporation documentation is what will control. So not necessarily, I know you said the church is in existence for 80 years, but what we will look at is the paperwork that you provide that states your incorporation date. So that will be governing. I don't think there is a way to overrule.
No. In fact, here's a similar question.
And we have a similar question that states, if a church or school has been in existence for many years and was unincorporated, but has only incorporated in the past few years, does the date of localism start at the date the church or school was founded, or the date that the Secretary of State granted the Articles of Incorporation? So again, in this situation, it is the date that the Secretary of State's records govern. So the Secretary of State's records govern as to when the organization was formed. So again, what we will look at for community presence and date of community presence is going to be based on the records and paperwork of the state. So this is similar to one I just answered. We intend on filing an application for an LPFM. In Section 3A, we are a 3-member nonprofit board with no shares of stock. What do we put in 3A for percentage of votes and total percentage of assets? So again, similar to before, you would just put the percentage as equal among all 3 members. So that would be 33%. So there's 3 members, and just provide equal percentage of votes and total assets. So that's 33%.
Here's a question dealing again with call letters. Question reads, the call letters can only be applied for when a construction license has been approved. Actually, it's after the construction permit has been approved. And really, to attempt to even worry about that prior to that is really unnecessary on your part. Wait until the construction permit has been approved. We have someone at the commission, and I'll be glad to provide that information that specifically deals with the call letters, but not to worry until after the application's been processed, reviewed, and when the construction permit itself has been granted.
When you say there needs to be evidence of a meeting of minds regarding the antenna site, what documentation is required should there be any question raised by either staff or a competing applicant? Contemporaneous documentation is not necessary. However, if a dispute does arise, the issue is in general is resolved based on submitting affidavits.
And generally, I would say this, as someone who's been involved in that issue for a long time, you don't need a lease, but something in writing is recommended, I would think, just to keep in your own records. An email is sufficient, but if you get into a contest over recollections, it can get messy and it's unnecessary. So I think you ought to operate under the theory that something in writing is the best way to go.
I'll take this one. Is there a tool on the FCC's website to calculate the antenna height above ground level needed to avoid on-the-ground interference to a Class B commercial station about 20 miles away? The low-power service pretty much don't calculate interference contours or overlaps. We use distances. Spacing is what we use between the stations. So in this case, you would be interested in the spacing from the Class B station to your LPFM station site, and based on the frequency of those two stations is what you would use. And that's just a simple spacing table that's in the radio rules and under 47 CFR 73.807. And then the second part of this question, and is ground level or some other height above ground level used to determine the acceptable second adjacent channel interference zone? And it's kind of attacked from the other direction. You take how you're mounting your antenna, how high and where, and based on the second adjacent interfering station is how you determine the interference zone. And it's not necessarily the height of your antenna at your location that makes the interference zone large or small. It's pretty much the distance between the interfering station and your station is what kind of determines the size of the interference zone. So that's here again. That's just determined based on how you propose the station, and not necessarily how you mount your LPFM antenna.
Next question. Since we are just incorporating, one of the board members is also a board member on another LPFM station. Does this board member need to resign prior to us filling out, or can he resign pending successful application of our LPFM application? Also, we have filed for incorporation with the state but are waiting approval. Should we not receive full approval until after November 14th? Will our application be dismissed? So the first part of the question, the recusal pledge has to be part of the application, and it can be contingent on winning the LPFM license. So you do not have to resign prior to filing the application. The pledge can be contingent. The pledge to recuse can be contingent on winning the license. Regarding the second question, regarding incorporation after November 14th, so you have to be recognized by your state as a nonprofit when you apply for your LPFM license. So if you have not received your state's incorporation papers prior to the filing deadline, then you are not eligible to file the application. So to be eligible to file the application, you must be recognized by the state as a nonprofit prior to the deadline. So you won't be able to file if you're not recognized by your state.
Okay. Referring to technical section 6, questions 8A and 8B, can the FCC channel search feature be used to answer these questions and used as evidence to submit the required exhibits? And the answer is no. I think if you read on the channel, the FCC's channel finder, it's to be used just as a guide to tentatively select channels, and particularly on question 8B, which relates to the interference to translator boosters, that channel finder doesn't give you any of that information. So you need a little bit more technical analysis to be able to know for sure that your 8A and 8B questions can be answered properly.
Next question. Where it is not possible within the LPFM height and power limits to serve the entirety of a well-defined remote community with one station, will you consider waivers to the multiple ownership rule limiting a non-public safety entity to one LPFM station? The applicant here is located on an island 20 miles offshore with no local radio or TV service. And if not, could two existing bona fide organizations with no board member overlap apply for licenses with a plan to share programming to provide community-wide service? So with respect to the waiver, you could ask for a waiver, but waivers generally are unlikely. We generally don't give waivers in these situations. With respect to the two bona fide organizations applying for licenses, if you truly are, as you state, separate entities, then two licenses can be issued. With respect to sharing programming, there is no prohibition on sharing programming. However, if you are considering applying for a point based on local program origination, both stations cannot apply for that extra point. So the one station's programming cannot count toward the other station's programming pledge for local program origination. So both stations cannot apply for the local program origination pledge. And we would also point out that our regulations, 47 CFR 73.879, states that an LPFM licensee may not retransmit either terrestrially or via satellite the signal of a full power radio broadcast station. So that's another thing to keep in mind when you're thinking about programming your station.
I had a question about community where there's more than one frequency available. Two applicants apply for the same frequency. Will the commission reassign one of the applicants to a different frequency so they can both qualify without any problems? As a general matter, the commission does not modify proposals such as this. So the way this could play out is when we announce these two applications as mutually exclusive by public notice, either or both of them would have the opportunity to propose the other channel. So just as a general matter, it's on the applicants to decide their fate in that case.
In the instance of a university, the LPFM antenna will be mounted on a building roof. The second adjacent interference contour will hit that same building, but not the ground. In this case, the building is administrative offices for the university, but might be the student dormitories. Is either building mounting acceptable for a second waiver adjacent waiver? The answer is yes, if the buildings are not occupied, and I doubt they are. So if they are occupied, it wouldn't be approved for a second adjacent waiver because you have to show no interference population.
Next question: Is there a way for established unincorporated organizations without state documents to apply? For example, a 100-year-old church. So again, this is based on state law. If your state recognizes unincorporated organizations, then you are eligible. But again, this has to be based on state law. So again, look to your state law as to whether or not it recognizes unincorporated organizations.
They can still incorporate, they just wouldn't qualify for the preference.
And then you could still, and even if your state does not recognize unincorporated organizations, just a reminder, you can still, at this point, apply to your state for incorporation. So you can, in which case you'll be eligible to apply. You won't be able to claim the 1-point credit for the 2-year community presence. But even if you try to get state incorporation now, you can still be eligible to apply.
Jim, do you want to do that?
I'm not ready for this one yet.
Okay.
Do you have one? Do you want me to go?
Go ahead.
Please delineate what is meant by public safety. For example, can a proposed radio station provide educational programming relating to health and healthcare awareness under the aegis of public safety or some other issue that will inform someone on their well-being, either physically or spiritually? So I think the main point here is that if you are an entity proposing to operate a public safety station, you have to be able to show that you actually have jurisdiction within the service area of the proposed station pursuant to our regulation 47 CFR 73.853B3. Again, if you look to 73.853B3, it will be important for you to show that you actually have jurisdiction within the service area of the proposed station.
Regarding Section 6, Exhibit 12, all available software indicates the channel we are applying for is available without interference issues. Not being an engineer, does a list of adjacent channels showing their respective geographic distance suffice? The question 8 interference question is just a certification, yes or no, and yes means you don't have to supply any kind of an exhibit. If you select no, then you're more than likely trying to use a second adjacent waiver process, and then that's when you would need an exhibit. So you can submit a list of adjacent channels if you like to, but it's not necessary.
I had a separate question about 73807, the fact that the second adjacent and third adjacent spacings in 73807 are the same. Frankly, the third adjacent spacings are only in there for a variety of reasons. Stations that are in the border zone that have to protect Canadian and Mexican stations, third adjacents would be applicable there. Radio reading services that offer certain types of stations that offer radio reading services on the subcarrier also have to be protected on a third adjacent channel, and there are also some specific interference protection issues that come into play, pretty much for low powers that are operating that have already been authorized. And those are really the only reason for the third adjacent spacings being in 807. Generally, stations operating on a third adjacent channel do not require protection. It's just those spacings are left in there for very specific situations.
I have one over this way about getting started. The writer writes, I'm interested in submitting my application for a low-power FM radio station and have filled out Form 318. I've searched your website and cannot find where to upload my file. Please let me know how to proceed. I'm going to give you a quick answer. There are two people, including myself, who can give you a hands-on, kind of like almost like a GPS presentation to you. My direct number, my name is Conrad Hurling, is 202 followed by 418-2769. And my partner in this effort, David Trout, is at 202 followed by 418-2752. There is a link, but the link would take about 3 minutes to read, so.
Conrad, I think they filled the form out in paper form and they're trying to upload it, so they didn't go into the electronic filing system.
Well, but they're still going to need to be able to access the electronic
I know,
filing.
but you should explain that you don't.
Yes, thank you. Looking at this also, please know that in order to file the application, it has to be electronically filed. So a paper filed representation will not do. It does ultimately need to be information that's submitted electronically over the internet in order for the application to be accepted and not returned.
Through CDBS.
And through our CDBS electronic filing system.
Next question. If your station is to be student-run and your university does not have any other broadcast licenses, should you still list the Board of Trustees of the university on the application, or should you list the current student board operating the station? So one point I would make is if you choose to list a student board, it is going to raise questions about whether the applicant is properly formed under state law and for comparative purposes, whether or not the the organization has existed for at least 2 years. Also, in our experience, the university itself usually prefers to have its board of trustees listed so that the university clearly retains legal control over the situation. And I think even just when you think about turnover, there's usually less turnover with the board of trustees instead of the students.
Our proposed LPFM application will be using a second adjacent waiver. The FCC curves show that we are within the 60 dBU of the full power station, but there is considerable terrain blockage between our proposed antenna location and the second adjacent full power station. Can alternative showing, such as Longleat Rise, demonstrate that there will be no overlap between the 100 dBU interfering contour and our application in the 60 dBU service contour of the full power station? And the answer is yes. The second adjacent waiver rule says that the LPFM station must establish using methods of predicting interference, taking into account all relevant factors, including terrain-sensitive propagation models. That's what the Longleat Rise is. Its proposed operation will not result in interference to any authorized service. So there's not just one way to do this. So this looks like if this showing would prove that case, then you can use that.
Yeah, one clarification on that. Certainly, everything Gary has said is correct. However, the use of any kind of alternative prediction methodologies require a significantly higher level of review. So I would caution applicants against this because it will significantly delay the review of their application. It's just an entirely different level of review that has to go into these things. So we are looking at significant delays should they choose to utilize that method.
Next question. If the headquarters changed address since the articles of incorporation were filed, is an affidavit affirming it's the same organization sufficient? Yes, or you can file an exhibit, which would also be sufficient, either in the case of an address change or even in the case of a name change.
I got a kind of a follow-up on one of the first, getting a lot of questions on second adjacent waivers and the interference zone on the building, the different types of buildings. And one of my first ones was the building was a church, and I said that would be okay, and it's not necessarily so. It may be okay. Pretty much important to note that we take all the waivers individually on a case-by-case basis, so can't give blank answers to everything, other than if a building is occupied, the waiver will more than likely not float. So a waiver for a building such as a church, we would have to look at that and determine whether it's regularly occupied or not, or if you can demonstrate that the interference is not covering that any area that is occupied. So just wanted to make it a little bit more clear on these interference zones for second adjacent waivers.
Next question. Our nonprofit school presently is the licensee and operates an LPFM, but is not a certified school nor a university. We've operated another campus in a different state for 3 years. Can that campus, given that it has a separate board, qualify for an LPFM license for a student-run station? The separate campus is not eligible unless it forms a new organization under state law. So it does have to form a new organization under state law to be eligible. I'll take the next one too. Can a nonprofit charitable organization, such as a hospital, apply for an LPFM license? It is not a nonprofit educational organization. It is not a nonprofit educational organization. So I think, for example, I think if you look at the NCE stations that we have on air right now, I think it's evidence that there is a broad range of what is considered educational programming. Our requirements is not restricted to formal educational programming. So as long as there is some educational purpose, you would be eligible to apply.
Okay, we're getting a lot of follow-up questions about second adjacent waiver requests. Here's one asking if they can submit letters from people within the interference area to indicate their willingness to accept the interference. That's absolutely not something we would allow. The standard is that there's absolute lack of population within the interference area, so any type of situation like that would not be permitted. As far as the building issue and the differentiation between a church and a residence and an office building and a chicken coop, the fact of the matter is if there's any kind of structure in the interference area, we are going to assume that it's possibly occupied, a residence, somebody possibly works there. Any of these situations, the burden is on the applicant to demonstrate that there is an absolute lack of interference and a lack of population within that interference area. If we have any reason to doubt the showing, it's like I said, the burden is on the applicant, so they have to make this absolute zero population showing. And obviously this is more challenging in more urban environments, but it's a fairly hard line test.
Since a government entity can apply for other than a public safety license, how does the application allow for that? We can't check as a nonprofit or tribe, so I'm unclear as to how to apply for other than a public safety as a city. So in this case, we would recommend that the municipality check the box as a nonprofit educational organization, given that education is a normal function for local government. So again, you should check the box as a nonprofit educational organization. Next question, do you have to be a 501c3 organization to apply? So again, no, I would remind applicants again that you must be formed as a nonprofit organization under state law. So that means 501c3 organization is not necessary. In a related question, can a nonprofit deemed to be a 501c7 as a group to be an applicant? So again, please look to your state law. Our eligibility as a nonprofit organization will be based on state law. So do look to your state law to determine if you qualify as a nonprofit. This is a two-part question. Question one, on the Form 318 for the contact list, can be that, hold on. So, okay, question one regarding contacts on Form 318. Can the contact represent the organization, or is it the technical assistance with the engineer's name? Which one should be listed under the contact name and address? Question two, the church nonprofit has a permanent P.O. box address, and the organization also has moved to a new location. Which address should we use for a contact address? Which should be listed on Form 318? So essentially, it's really up to the applicant to list the appropriate contact and address. However, I should point out that your localism and your community presence will be based on the actual location of your headquarters. So again, it's up to the applicant to determine which contact address and information they want to list, but your localism and community presence will be based on the actual location of your headquarters.
And the engineer has his own box at the back of the application in Section 6, certification. So if you want to know where to put if you have an engineer working on this and he's working on the technical section, he's got his own, he or she has their own certification box in Section 6.
Thanks, Gary. So Section 2, legal parties to the application, please explain Part B and what should appear in Exhibit 3. What I would recommend, this is probably a longer answer than we have time for here. I would make two recommendations. One is if you haven't read the Form 318 instructions, to do that. That provides a lot of information. Also, we did provide this type of information in our first webinar, which is archived on the FCC's website. So I would also recommend you take a look at that. It goes through the entire application, and we do discuss the type of information that we're looking for. If you still have questions, we will continue to answer questions after the webinar at the same addresses, lpfm@fcc.gov, or on Twitter. So if you've reviewed the Form 318 instructions and looked at the webinar and you still have questions, we will answer those questions after this webinar, but I do think this question will take a longer time than we have time for today.
I have a question about, is a list of FM translator input frequencies available on the FCC database? In fact, there is, and on October 18th, the Bureau released a public notice. It's DA 13-2030. It provides very much detail as far as where to access this data from the Commission's website, and also the specifics of these data files and how to find the information about the input frequencies that folks need to protect. It's October 18th. It's actually on the Audio Division website where you can find that public notice also.
I have an informational piece here. Question came in asking for the website to get to the page where you would log in. It's a long site, so you've been warned. It's licensing. Let me make sure. There we go. licensing.fcc.gov/CGI-bin/WS, as in World Series, .prod/forward/PROD/forward/CDBS/menu.HTS. And rather than repeating that, again, I'll repeat my number. You can call me directly, 202 followed by 418-2769. The next question is dealing with the FCC registration number. Do we need to get an FRN number to complete Form 318, or is registration through CDBS enough? No, you do need to register with the FCC registration service in order to give birth, so to speak, so that you will have an FRN. There's a separate site for that, and maybe I will pull it up and then I can read that to you as well. Again, you can call me up if you would like.
Next question. In dealing with a public safety license, would a non-English speaking organization qualify under this? So the answer is yes, as long as the organization does have jurisdiction in the proposed service area as required by our rules. And just so that you know, the rule is 47 CFR Section 73.853B3. We also have that information in the form instructions. But again, if you are a non-English speaking organization, you can qualify as long as you do have jurisdiction in the proposed service area.
Our station is considering streaming our audio via the internet from our studio to our tower site. Considering our ETA's encoder decoder is at the tower site, is this an acceptable methodology for a studio transmitter link by the FCC standards? The FCC really doesn't have any standards for studio transmitter links, not unless there are it's an radio frequency, a licensed radio frequency link, and then you have to have that link licensed. But audio sent from studios to towers are done by many ways: telephone lines, over the internet, RF, microwave, and we really don't have any rules or regulations on how to do that. So this should work. If it works for you, it should work. It should be okay. There's no nothing you have to look at other than that it gives good quality audio.
Who should be listed as parties to the application when a municipality is the applicant? The relevant governing board should be listed. And here's a similar question. Who qualifies as a board member? This question says many Catholic parishes don't have boards per se. Should a parish's advisory finance council members be included, or should the board members be left blank? So in cases where it's unclear, we do ask that the applicant make a good faith effort to list parties that are going to be in control of the entity. And you can also attach an exhibit if there is ambiguity. But again, if in general, list board members or the governing board. If there is a question about that, do consider and think about who the parties are that will be in control of the entity or the LPFM station when filling out that question.
I had another. Thanks. I had another follow-up on the second adjacent waiver issue. This person indicates that clearly the word occupied refers to somebody living in a building, but does it apply to somebody working in the building? Our view is if there is a building, we must assume it is occupied. That may mean people live there. It may mean people work there. It may mean people congregate there on a regular basis. We don't know unless you tell us. So the bottom line is, if there is an interference area that includes some type of structure, and you don't think it's a structure that should be considered as occupied, you need to provide, any kind of documentation or evidence to that effect. So, I can't stress this enough that folks, as for these second adjacent waivers, it's very important that folks include some type of map or a Google Earth representation of the interference area, assuming it's large enough to include that, and document any type of structures like this that they believe should not be considered occupied structures.
Okay. I have the site for the FCC registration number, the FRN. It's the following. It's a bit shorter than the previous web page that I provided. Again, this is for the FRN. It reads apps, that's apps.fcc.gov/CORES, that's spelled CORES, followed by WEB, so CORES Web. The W in this case actually is capitalized, so CORES Web /public home. The word home is, the H is capitalized, .do. I'm going to read that just one more time. apps.fcc.gov/CORES web. That's all together, one word. /public home period or .do. Again, you also can give me a call at the number we've already provided.
Next question, what is the application fee for a nonprofit organization filing for an LPFM? The LPFM application fee, there is none, so you don't have to worry about any filing fees when you file your Form 318 application. Can you have an LPFM station in a house in a residential area? Yes, as long as it meets all technical and engineering requirements.
Yeah. The problem there might be local ordinances or local rules having a broadcast station in a residential area, but the FCC doesn't look at that stuff, so you'd be well advised to check your local ordinances in your city, town, or county where you live.
I had a question about the length of the build-out period for the construction permits that we're going to be issuing. The construction permits that we issue have an 18-month period in which applicants are required to construct and begin operation of the stations. However, low-power FM stations that need an additional 18 months can simply ask for it, and that permit would be reissued with a new expiration date. So it's a guaranteed 18 months, and should folks need longer, they can get an additional 18 months on top of that.
So next question is, what documents are needed to show eligibility for city governments and unincorporated towns? So there are no documents required. You fill out the form and provide the exhibits listed in Section 2, Question 2. You should look at what exhibits are necessary in Section 2, Question 2. Aside from looking for extra points for local programming, what is the minimum number of hours or day or week for any and all programming, and is there a minimum for local programming? So we require at least 36 hours per week. However, any station with less than 12 hours a day may be subject to a time-sharing requirement later on. And there must be 8 hours of locally originated programming for any applicant claiming a point for local programming. So again, generally you are required to provide 36 hours of programming per week. If you don't provide that minimum level, or if you don't provide a minimum level of 12 hours, you may be subject to a time-sharing requirement later on. And if you do claim a point for local program origination, you are required to provide 8 hours of that locally originated programming. What name should be used on the application if it is a unit of a nonprofit using the parent nonprofit's state incorporation date? In that case, the parent nonprofit organization should be listed as the applicant.
I'm just taking that way. Okay.
Could you please provide some more information on acceptable programming to qualify for the local programming origination point? Does the programming need to be live? For example, would previously recorded content that was produced locally at the main studio qualify for the point? I would ask that you look in the Form 318 instructions on page 9. This is directly addressed in the form instructions. So again, the instructions to Form 318 on page 9 directly addresses those questions.
To get to the PDF of Form 318, the way to go to it is go to the FCC homepage, then click on the button for Tools and Data, then click on Forms, and then as you scroll down that page, you'll see the number 318. If you click on that, that'll get you to the PDF, which has the instructions that you can download or print out.
And Carol, consistent with that effort to make things simpler, on the FRN, if you go to fcc.gov, and once you're at fcc.gov, you'll go to the 4th tab. There are 5 tabs at the top. The 4th tab reads Business and Licensing. Then from there, go to the 3rd option down that says Online Filing. And just one more step after that. I'm just pulling it up right now because I want to make sure I direct you correctly. The next page will read Online Filing, and you'll scroll down. It's I believe the 7th paragraph, and that lead to that paragraph reads Obtaining an FCC registration number. Click right there, and that will take you to the FRN and where you could register.
Next question. What proof should be submitted that we will have our studio manned at least 20 hours a week? Again, it's just a pledge, and we do expect that if you make such pledges that you will commit and carry out those pledges. Does a board member holding stock in a publicly traded company that owns broadcast stations have to recuse themselves?
I can answer.
Yeah.
If an individual, let's say, holds stock in Clear Channel or Cumulus or another publicly traded radio company, it's very unlikely that they would have to recuse themselves. They're not attributable unless they are a board member of the company or an officer of the company, or they have 5% or more of the outstanding voting stock of the company. So it's pretty unlikely that your local board member is going to fall into one of those categories.
Thanks, Tom. In order to comply with having jurisdiction within the service area for public safety applicants, does that mean you must have jurisdiction over 100% of the area within the 60 dBU service area? I think our expectation is that you would have 100% jurisdiction.
We don't know, though. It's never been litigated. I think certainly if it's 50% or more, then there's not going to be much question. Once you get below 50%, I don't know how it would go. If you submit an application, there's no cost to filing the application. So I would say file the application and make the best showing you can.
All right, I have yet another follow-up question on second adjacent waivers. Somebody has asked about public roadways within the interference zones. As Gary indicated earlier, the basis for this process is deeply rooted in the rules and the policies that we apply to the FM translator service. I would say if anybody wants to see any of the, I would say the most significant published decision in that regard would be the Living Way Ministries decisions that have come out of the Commission. These decisions are actually referenced. I'm looking at the fifth order on reconsideration in the low power proceeding. It's in footnote 158 of that order. There is a reference to the Living Way Ministries decision. In that decision, it spells out the occupied structures issue, and it also indicates that we will protect any major roadways that run within the interference zone. So major roadways are protected.
Next question. To claim a point for local programming, an applicant pledges 8 hours per day. What happens if they can't fulfill the 8 hours per day and applied with sincere intentions, since many are still in the planning and hoping to get a license? So again, if you make the pledge, we do expect you to fulfill those pledges. We do have random audits to make sure you are fulfilling your pledges. And just a reminder, we said this early on in the beginning, but prior to file, we do expect you to, I guess, before we give out the licenses or make decisions on who gets licenses, we do expect you to maintain the accuracy of your application. So if at some point prior to us granting licenses you realize you cannot fulfill that pledge, you should amend your application and state that you will no longer be able to meet that pledge. But again, we do random audits, and we do expect you to fulfill that pledge. A similar question about the pledge for local program origination, and what if you pledge to provide local programming, but then you end up having no other applicants or competing applicants? Is there a minimum? Again, you are bound by what you pledge in the window. So if you have pledged to provide 8 hours of programming, you should, or you do have to maintain that pledge. They can, if there's no competition, can they amend it?
Yeah, I guess if you find yourself in a situation where there are no competing applicants, you before the application is granted, you could amend the application to eliminate that pledge, and then you wouldn't be bound by the pledge.
So this is an eligibility question. As a church institution, the section states the applicant certifies, and should we check B, yes, and A, C as no as a church? So for that question, you should check yes in section 2, question 2A, and provide the exhibit required by that question.
So I think earlier somebody mentioned that the environmental and RF exposure worksheets have been recently made available to the electronic Form 318 on the Commission's webpage. Had a question about whether or not due to the fact that we just released those worksheets within the week, whether or not the Commission would extend the application window past November 14th. And the expectation is that we will not be extending it because, for that reason at least. And one note about those worksheets, particularly the RF worksheet, I've had some specific questions about them. These are intended to be worst-case guidelines. There are many ways that applicants can utilize different types of antennas, to come into compliance with the emission requirements. And you can actually have situations where antennas are located even closer to the ground or occupied buildings where you would still comply with the rules. And the worst case, if you do not comply with the RF limitations, you may receive an inquiry from us about documenting your compliance, or you may receive actually a conditioned construction permit, which would allow you to go ahead and construct and simply provide the RF documentation at license time. So none of the problems presented by a potential issue from those worksheets will necessarily result in dismissal of the application. It would simply result in an inquiry from the staff.
So we have gone about 15 minutes over time, so we'll take about 5 more questions before we close shop today. One next question is, what latitude is there for schools which might have extended vacations or times when no one is there? Are they liable to be subject to forced time sharing if they fulfill the required hours at all times except for those brief periods when the facility is closed? I don't think we have specifically addressed this in the LPFM context, but in the non-commercial context, it is okay for you not to be on the air during holidays and vacations, so that will not be held against you. Next question, 75% of the board members need to be within 10 miles of the station. Is that 10 miles of the transmitter site or the broadcast studio? Is that in air miles, or would that be driving distance? It's 10 miles to the transmitter site.
Yes, direct.
Is it air miles or?
Yeah, air miles as crow flies, and
Okay.
within markets up to market Arbitron market 50. If it's over larger than Arbitron market 50, it's 20 miles. Smaller, larger, smaller, right? The smaller the market, below 50, it's you have 20 miles a distance.
If there is more than one vacant frequency, may an applicant file mutually exclusive applications for both in hopes of winning one? So no. So again, as I mentioned earlier, you can only file one LPFM application. So no, and I do want to stress that again, you can only file one application in this window. So I think that is the last of the questions. A reminder that we will continue to answer questions. You can call us, or you can, again, continue to send questions to lpfm@fcc.gov or hashtag LPFM questions. So we will continue to answer questions until November 14th. So if we haven't answered your question today, or if you have follow-up questions, please feel free to send them in. And just quick, I didn't introduce everybody, but we did have the whole staff here helping with questions. Jim Bradshaw, Tom Hutton, Gary Lurs, and Conrad Hurling. And so we'll all be available for the next few weeks to answer your questions.